Hello, everyone. Imagine standing in a courtroom where a powerful judge tries to silence you, not just your words, but your credibility. What would you do? Today, we dive into the gripping true story of Karoline Leavitt, who faced public humiliation, only to see the tables turn when attorney Pam Bondi stepped in. Stay with us, because this isn't just a courtroom battle, it's a lesson in how truth, strategy, and resilience can outsmart even the highest authority. Ready to find out what happened? Let's begin. Sometimes power doesn't shout, it waits, and then it strikes. The Eastern District of Virginia's courtroom 4 was packed. Every seat was taken. Even the overflow room next door was nearly full. Reporters, aides, and legal analysts filled the gallery. Some leaned forward, notebooks open, while others sat frozen, sensing a storm brewing. Karoline Leavitt stood tall at the witness stand. Her deep blue blazer blended with the polished oak behind her. She looked composed, but inside, every nerve was on high alert. Across the courtroom, Judge Douglas Whitaker stared down at her, his cold gray eyes sharp beneath his glasses. His bench was elevated, symbolic of the authority he wielded and the intimidation he preferred. "Miss Leavitt," he said, his voice clipped, "this is the second time you've interrupted the proceedings." Karoline's attorney shifted, ready to object. But Pam Bondi, seated at the defense table, rested a steadying hand on his arm. "Not yet," her look seemed to say. Karoline took a breath. Her voice didn't waver. "Your Honor, I'm not interrupting. I'm correcting a factual misstatement." A ripple went through the gallery. Some reporters scribbled furiously. Others just watched, wide-eyed. Whitaker's lips tightened. "Miss Leavitt, this is a court of law, not a campaign rally. You were warned." "I am responding under oath," Karoline replied. "That's not grandstanding. That's my obligation," her attorney murmured. Textbook response. "Well done." But Judge Whitaker was not impressed. In fact, he seemed to welcome the challenge. "You are disregarding courtroom procedure," he declared. "Your behavior is disruptive and deliberate." Pam Bondi leaned forward slightly, her pen poised above her yellow legal pad. She didn't write anything. She was watching the judge's every move. Karoline tried again. "I respectfully disagree. I have the right to clarify." Whitaker slammed his palm on the bench. The sound echoed like a gunshot. "Enough." The room went dead silent. "I find Miss Leavitt in contempt of court," he announced. "Bailiff, take the defendant into custody." Gasps erupted. "Your Honor, this is excessive." Karoline's attorney stood. "We object to, objection is overruled." Whitaker's tone was final. The bailiff, caught off guard, hesitated before approaching Karoline. "Ma'am, please stand," he said quietly. Karoline nodded. There was no panic in her eyes, no begging, no tears. She stood gracefully, adjusting her blazer as though preparing for a photograph, not an arrest. "Hands behind your back," the bailiff instructed. She complied. The cold steel of the handcuffs bit into her wrists. The sound of them locking snapped through the room like a verdict. Reporters frantically jotted down every detail. Though cameras were banned, a few cell phones stealthily captured the moment. Even the prosecutor, seated opposite, looked unsettled. This wasn't how most hearings went. This was personal. Karoline's attorney turned to the judge. "Your Honor, we request a recess to address this ruling." Whitaker didn't blink. Denied. At the defense table, Pam Bondi closed her legal folder with quiet precision. Her expression was unreadable, but her mind was racing. He moved too quickly, faster than even I predicted. Which means, he's not thinking clearly anymore. The bailiff gently touched Karoline's arm, ready to lead her away. Pam's eyes didn't leave the judge. She was measuring him, not his words, but his strategy. And what she saw confirmed her instincts. Judge Whitaker wasn't enforcing the order. He was making an example out of Karoline. But he had overplayed his hand, and Pam Bondi was ready to strike. Before the bailiff could move Karoline toward the holding area, Pam Bondi stood. The shift in the courtroom was immediate. A new current swept through the air. Pam didn't rush. She didn't speak until the room stilled again. "Your Honor," she said, voice calm but resonant. "The defense formally objects to this ruling." Judge Whitaker didn't even look surprised. "Your objection is noted. It does not alter the finding." Pam nodded. "Respectfully, Your Honor, my colleague and I filed an emergency stay earlier this morning. It applies directly to any enforcement actions, including contempt-related custody." Whitaker leaned back, almost smirking. "No such stay exists in the record. It does now." Pam reached into her folder, retrieving a stamped document. She held it high. "Clerk, please enter this into the official record immediately." The court clerk approached, took the papers, and scanned the heading. "Filed under Judge Matthew Harlan, U.S. District Court, Eastern District of Virginia, She read aloud. The gallery buzzed. Even the prosecution leaned forward, their confidence faltering. Judge Whitaker seized the document. His eyes darted across the page. This was filed at 9:45 this morning. Pam answered smoothly, correct, signed by Judge Harlan. The stay halts any contempt enforcement until federal review. Whitaker's gaze flicked toward the clock, 10:02 a.m. His lips pressed into a hard line. He didn't speak. He couldn't. Pam added, we followed every required federal procedure. The court is now subject to those limits. For a moment, the power shifted. Whitaker's robe, the elevated bench, the very authority he wielded, suddenly all seemed less imposing. We will recess for 10 minutes to review this filing, Whitaker finally announced, voice taut. The gavel cracked sharply. But even as the judge disappeared into chambers, the room stayed tense. The bailiff hesitated by Karoline's side. Until instructed otherwise, he said softly, the restraints remain. Karoline nodded. She wasn't surprised. She wouldn't give the judge the satisfaction of breaking. Pam moved closer. Her words were low but firm. You're not going anywhere. Karoline exhaled. Her eyes didn't betray the pressure she felt. Her attorney whispered, Pam, the stay's language? Tight. No room for interpretation. An assistant district attorney approached, frowning. You filed without notifying our office. Emergency procedure, Pam replied coolly. No notice required. You could have given me a heads up. This wasn't a courtesy filing, Pam said. It was necessary. Karoline glanced at her. You filed this before today? Pam nodded. We anticipated this move. Karoline's voice dropped to a whisper. I didn't think he'd go this far. Pam's eyes hardened. He was counting on that. Across the gallery, even the reporters sensed it. This wasn't just a legal maneuver. This was Pam Bondi turning the procedure into a weapon, and she wasn't finished. The 10-minute recess passed slowly. Coiled through the courtroom like a live wire. Karoline remained seated beside Pam, the cuffs now removed, but the weight of what had happened and what could still happen hung heavy in the air. Judge Whitaker returned, his robe trailing like a dark shadow. His expression was measured, but something had shifted. His attempt to jail Karoline had failed. He knew it. Everyone knew it, but power seldom surrendered quietly. The court acknowledges receipt of the emergency stay, Whitaker announced, voice carefully controlled. In light of the stay, no enforcement actions regarding contempt will proceed at this time. A murmur rippled through the gallery. Pam didn't flinch. She knew what was coming next. When a judge couldn't silence you physically, he would try to silence your credibility. Whitaker adjusted his glasses, scanning the papers before him. We will now proceed to the evidentiary portion of today's hearing, he said. The court notes the federal stay, but will continue within its remaining jurisdiction. Karoline's attorney nodded cautiously. Pam remains, her focus razor sharp. The prosecution may call its next witness, Whitaker instructed. The assistant district attorney, a man named Eric Samuels, stood. He wore the confident smile of someone who thought he finally had the upper hand. The prosecution calls Andrew Keller, Samuels declared. A man in his early 40s rose from the gallery. Short cropped hair, charcoal suit, wire-rimmed glasses, the uniform of a bureaucrat who lived and breathed numbers. As Keller approached the stand, Pam leaned slightly toward Karoline. Stay steady. This is his pivot. Karoline gave a subtle nod. Keller was sworn in. His voice was clear, professional, almost robotic. Please state your name and position for the record, Samuels prompted. Andrew Keller. Senior Labor Market Analyst. U.S. Department of Labor. Samuel stepped forward. Mr. Keller, did you review the public remarks made by Ms. Leavitt during her televised interview this February? I did. Specifically, her statements regarding projected job losses under proposed federal policies? Yes. And did you compare those statements against official Department of Labor data? I did. Pam's pen hovered above her notepad. She didn't write. She listened. Samuels gestured toward a display monitor. Mr. Keller, what did your review reveal? Keller tapped the screen. A chart appeared, showing a comparison of Karoline's cited figures versus the department's official projections. The numbers presented by Ms. Leavitt projected job losses at approximately 450,000, Keller explained. Our department's most conservative estimates were substantially lower, around 175,000. A ripple moved through the gallery. Reporters scribbled furiously. Karoline remained composed, but her pulse quickened. Samuels continued. So, her figures exaggerated the potential job loss. By what percentage? Over 150%, Keller replied. Pam leaned toward Karoline. Don't react. Let them play their hand. Karoline nodded, jaw tight. Samuels turned back to Keller. In your expert opinion, Were Miss Leavitt's statements factually consistent with your department's data? No, Keller answered. The variance was significant and misleading. The words hung heavy in the air. Pam could almost feel the prosecution's confidence swell. Samuels paused, letting the implications settle with the judge, the gallery, and the public. No need for dramatic accusations. The numbers were the weapon now. Samuels folded his hands. No further questions, Whitaker nodded. Defense may cross-examine. Karoline's lead attorney, Daniel Reeves, stood smoothly. His calm contrasted with the prosecution's smugness. Mr. Keller, Reeves began, are you aware of the sources Miss Leavitt used to calculate her job loss projections? I was not provided with her sources. So it's possible, Reeves pressed, that she relied on alternative models or projections? It's possible, Keller admitted cautiously, but they would not align with official data. Reeves nodded. Is it also true that economic projections, especially regarding potential job loss, can vary widely depending on the modeling assumptions used? Yes. And would you agree that federal data often provides national averages, whereas alternative studies might account for regional factors or industry-specific trends? That is correct, Keller conceded. Pam smiled slightly. Keller had just admitted what they needed the record to show. Reeves continued. So while you disagree with Miss Leavitt's figures, you cannot definitively say her projections were fabricated or knowingly false? Keller hesitated. I can't speak to her intent. Thank you. No further questions. Reeves returned to the defense table. Pam leaned in. He's soft. He can't carry their argument beyond data variance. Karoline nodded, her nerve steadying. Judge Whitaker, however, was not finished. Mr. Keller, Whitaker interjected, in your review, did you find any evidence that Miss Leavitt consulted with labor experts from advocacy groups when forming her projections? I have no such evidence. Very well. Pam's eyes narrowed. So this was the real strategy. Not just attacking numbers, but fishing for political coordination. A campaign finance violation. Whitaker was laying the groundwork for a bigger accusation. Karoline's attorney recognized it too. He scribbled a note and passed it to Pam. He's shifting to intent. Campaign ties. Pam wrote back, let him. He's exposing his strategy. The courtroom shifted. The gallery sensed it. What began as a debate over numbers was morphing into a question of trust and integrity. Whitaker turned to Samuels. Does the prosecution wish to explore this line further? Samuels shook his head. Not at this time. That was telling. The judge nodded. We'll proceed with the next witness after a brief recess. The gavel struck. Pam leaned toward Karoline. He just showed his hand. He can't jail you. He can't discredit your data outright. Now he'll try to suggest that you coordinate with political groups. Karoline's expression was resolute. Then we'll stop him there too. Pam smiled faintly. That's the plan. As the courtroom emptied for recess, the reporters had already decided what the new headline would be. Data under fire. Credibility question. But the defense is far from finished. The courtroom reconvened after the brief recess, but the energy had changed. Judge Whitaker returned with his typical composed demeanor, but those watching closely could see the slight rigidity in his posture. His first attempt to discredit Karoline through contempt had failed. His second to undermine her data had weakened. But he wasn't done. Defense, Whitaker announced, you may proceed. Daniel Reeves, Karoline's lead attorney, stood confidently. Your Honor, the defense will call our own labor analyst to address the data variance questioned by the prosecution. Whitaker nodded with a trace of impatience. Proceed. Reeves turned toward the gallery. The defense calls Evan Patel. From the third row, a man rose. Early 30s, sharp gray suit, a quiet authority in his stride. As he approached the witness stand, he adjusted his tie and nodded respectfully to the judge. Pam leaned toward Karoline. He's ready. Karoline gave a small nod. She could feel the momentum shifting, but also that the battle was far from over. After being sworn in, Patel took his seat. Please state your name and occupation for the record, Reeves began. Evan Patel, independent labor economist and policy consultant. I specialize in regional labor market analysis. And did you provide labor projections used in Miss Leavitt's February interview? I did, Patel confirmed. At her office's request, I conducted a region-specific analysis that accounted for potential job losses under proposed federal policies. Were your findings consistent with the national averages published by the Department of Labor? Number? My models projected higher job losses because they included regional factors industries uniquely vulnerable in certain states. Reeves paced slowly. Can you elaborate on those factors? Yes. Some regions are heavily reliant on sectors like manufacturing and energy, which federal policies disproportionately affect. National averages smooth out those extremes, but local impacts can be much higher. A wave of nods swept through the gallery. Even a few journalists exchanged glances. This was the explanation the prosecution hadn't wanted the public to hear. Reeves continued, "Were your methods peer-reviewed or aligned with standard economic practices?" "They were," Patel said firmly. "Our methodology was published alongside the report. No one, including the Department of Labor, challenged the integrity of our approach." Pam scribbled a single word in her notebook. "Bulletproof." Reeves smiled slightly. "So, while Miss Leavitt's figures differed from federal estimates, they were based on legitimate, transparent analysis?" "Correct. Did you coordinate with any political organizations or advocacy groups while preparing this data?" "None whatsoever." "And were you compensated by any campaign or political entity?" "Number." "I was contracted as an independent consultant." The gallery stirred again. Pam caught the expression on the prosecutor's face-tight-lipped frustration. "No further questions," Reeves concluded. Whitaker leaned forward. "Prosecution, your witness." Eric Samuels approached the stand, but his confidence had noticeably waned. "Mr. Patel," Samuels began, "would you agree that presenting significantly higher job loss figures than official federal data could create public confusion?" Patel responded evenly. "Presenting data without context can create confusion. That's why our methodology was made public." Samuels pressed, "Isn't it possible that such projections might mislead the public or be used for political purposes?" Patel didn't blink. "Any data can be taken out of context. That risk exists with all public reports, including those issued by the Department of Labor." Pam smiled to herself. The prosecution was stretching, and the jury of public opinion in the gallery could see it. "No further questions," Samuels muttered. Whitaker didn't immediately dismiss the witness. Instead, he adjusted his glasses and addressed Patel directly. "Mr. Patel, did you at any point share your findings with political advocacy groups or PACs?" Patel frowned. "No, Your Honor." "Did Miss Leavitt's office request that you tailor the data to support any political narrative?" "Absolutely not." Pam's jaw tightened. There it was. Whitaker wasn't just attacking the data anymore. He was testing the waters for a larger accusation: intentional coordination with political groups. A campaign violation. Karoline's attorney rose swiftly. "Objection, Your Honor. This line of questioning exceeds the scope of the current evidentiary review." Whitaker held up a hand. "I'm merely clarifying for the record." Pam leaned toward Karoline. "He's fishing. This is his new strategy." Karoline's expression remained composed, but her eyes burned with quiet resolve. "Then we won't give him what he's looking for." As Patel stepped down, the momentum was clear. The prosecution had tried to discredit Karoline's numbers. The defense had countered with transparency, expertise, and integrity. And now, Whitaker's pivot to intent had been exposed before he could even fully form the accusation. The gavel struck. "We will adjourn for the day," Whitaker announced. "Proceedings will resume tomorrow at 9 a.m. As the courtroom emptied, Pam remained seated, reviewing her notes. Karoline leaned toward her. "What's his next move?" Pam didn't look up. "He'll try to make this about credibility and coordination. If he can't challenge the facts, he'll try to question your motives. And our response?" Pam finally met her eyes. "We stay 3 steps ahead. Starting tonight." The courtroom emptied as the afternoon shadows lengthened across the polished wood floors. Most spectators filed out, some glancing back toward the defense table. They didn't know it yet, but the real battle wasn't what they'd witnessed. It was what they wouldn't see. Pam Bondi remained seated, eyes fixed on her legal pad. She hadn't written a word in the past hour. She didn't need to. Karoline leaned toward her. "He's pivoting to coordination. That's his next move." Pam nodded. "And we'll be ready." But preparation wasn't enough anymore. It was time to act. That evening, long after the courthouse had gone quiet, Pam gathered with Karoline's legal team in a private conference room at a nearby office building. No reporters, no public statements, just strategy. Karoline sat at the head of the table, hands folded, her posture as calm as ever. But in her eyes behind the restraint was a fire that hadn't dimmed. "Pam," said Daniel Reeves, the lead attorney, "what's our next move? Do we go public about Whitaker's conduct? His bias has been obvious." Pam shook her head. "Not yet. Public pressure is noisy. Judges dismiss noise. They can't dismiss process." She opened a slim black folder and slid out a 3-page document. "I've drafted a complaint for judicial misconduct," Pam said. Karoline's brows lifted slightly. Reeves leaned in. "Based on what?" Pam turned the pages. 4 procedural violations. Documented, 2 during witness testimony overruling objections that violated state law. 1 during cross-examination disallowing lines of questioning that are standard practice. And 1 this morning, the contempt ruling issued while defense evidence was pending. She laid the final page flat. All breaches of judicial conduct, all verifiable. Karoline's communications advisor frowned. Won't filing this escalate things? Pam's eyes didn't waver. That's exactly the point. Whitaker escalated when he tried to jail Karoline. He escalated again when he shifted toward implying criminal coordination. Pam leaned forward, voice low and steady. We're not leaking this to the press. We're filing it under seal with the Fourth Circuit's Judicial Oversight Committee. Reeves exhaled. Quiet, surgical. Exactly. Pam nodded. No headlines. No distractions. Just process. She paused, letting the weight of the strategy settle over the table. Karoline finally spoke. Will the Fourth Circuit take this seriously? Pam's reply was immediate. They'll notice. And if Whitaker continues his behavior, this complaint will already be in motion. The next morning, just after sunrise, Pam entered the federal courthouse's Fourth Circuit administrative wing. The corridors were quiet, echoing only her footsteps. She handed the sealed envelope to a senior clerk. This concerns a pending case in the Eastern District, Pam said. Judicial conduct inquiry. Please confirm the receipt. The clerk glanced at the top page, reading just enough to see the case number and subject. Judge Douglas Whitaker. Received, he replied, stamping the cover sheet. It will be forwarded immediately. Pam gave a nod. No public notice, of course. She turned and walked away without another word. No cameras, no press, no statement. Just the silent weight of accountability moving forward whether Whitaker knew it or not. The next morning, courtroom 4 filled once again. Fewer spectators, fewer reporters. But the tension had only grown heavier. Judge Douglas Whitaker entered promptly, his robe flowing behind him like a curtain drawn across yesterday's failures. His expression was neutral, but his eyes betrayed the mounting pressure. We will resume proceedings, Whitaker announced, his voice sharp but lacking the firm edge it once carried. Prosecution, your next witness. Eric Samuels rose, now without the confidence he'd shown earlier in the trial. The prosecution calls Melissa Hayes. From the gallery, a woman in her early 30s stood. Auburn hair pulled back. Simple, professional attire. She carried herself with the quiet precision of someone used to managing chaos behind the scenes, not standing in the middle of it. As she approached the stand, Karoline whispered to Pam Bondi, "She was the associate producer from my February interview." Pam nodded. "She's important. Watch the tone." Melissa was sworn in and took her seat. Samuel stepped forward. "Miss Hayes, please state your occupation." "I'm a segment producer for Capital Today, a political affairs program." "And were you involved in the televised interview featuring Miss Leavitt this past February?" "I was." Samuels moved to the lectern, glancing briefly at his notes. "Did you coordinate with Miss Leavitt's office prior to the interview?" "I manage standard scheduling communications," Hayes replied. "Date, time, transportation, logistics. Were any talking points provided by Miss Leavitt's team?" "Yes. General areas she wished to discuss." "Nothing unusual." Samuel straightened his tie. "Did you or anyone on your production team receive guidance or messaging from any political advocacy group or PAC connected to Miss Leavitt?" Hayes blinked, then frowned slightly. Number Samuels pressed. "Are you certain?" "Yes. All pre-interview materials came directly from her office." A subtle shift rippled through the gallery. Reporters paused, pens hovering above notepads. Samuels tried again. "To your knowledge, did any political organization influence the content or direction of Miss Leavitt's interview?" "No, sir." Pam leaned toward Karoline. "He's losing the thread." Karoline nodded, her jaw tight but her eyes calm. Samuel's tone sharpened. "Were you aware of any coordination between Miss Leavitt and external political groups regarding the February appearance?" "Absolutely not." Samuels hesitated. His plan to pivot from data disputes to suggesting a deeper political conspiracy was slipping through his fingers. "No further questions," he muttered, retreating. Whitaker's gaze remained fixed on Hayes. "Defense may cross-examine." Daniel Reeves stood smoothly. "Miss Hayes, thank you for your clarity. To confirm, you were responsible for coordinating guest logistics and preparing segment outlines?" "Yes." "And at no point did any party outside Miss Leavitt's staff or your production team influence the interview?" "Correct." "Did your senior producers raise any concerns about the interview's content or messaging before or after it aired?" "Number." "It was treated as a standard political interview." Reeves offered a polite nod. No further questions. As Hayes stepped down, the tension in the room shifted yet again. Pam scribbled a quick note and slid it to Reeves. This was their linchpin. It just snapped. Whitaker's fingers drummed lightly against the bench. The courtroom could feel it now, not just the defense team. The prosecution's case was collapsing, but the judge wasn't ready to yield. Whitaker cleared his throat. The court acknowledges the testimony provided by Ms. Hayes as relevant but not dispositive. The burden remains on the defense to explain the discrepancies between Ms. Leavitt's statements and federal labor data. Pam leaned toward Karoline. He's retreating into procedural language. That's a defensive move. Karoline nodded. And tomorrow? Pam's expression was resolute. Tomorrow, we will push back harder, and we let the record speak. The gavel struck. We will recess until 9 a.m. tomorrow, Whitaker announced. As the room emptied, Pam remained seated for a moment longer, watching the prosecution table, the judge's bench, and the gallery. They weren't just defending anymore, they were winning. The following morning, courtroom 4 felt different. Gone was the frenzied energy of earlier days. Fewer reporters, no live bloggers. Only the core spectators remained, those who understood that in law, the quiet moments often mattered most. Judge Douglas Whitaker took his seat without ceremony. His expression was unreadable, but his usual air of command had dulled. This court, he began, voice steady but lacking its earlier sharpness, has reviewed all testimony, documentation, and closing statements presented over the course of these proceedings. Pam sat unmoving. Karoline leaned slightly forward, hands folded, face calm. Whitaker continued. While discrepancies in labor projections remain, no evidence has been presented that demonstrates deliberate or coordinated falsehoods on the part of Ms. Leavitt. There it was. A wave of muted reaction passed through the room. Even the prosecution team seemed to sag in their chairs. Whitaker wasn't finished. Furthermore, this court finds no basis to impose sanctions or pursue disciplinary actions. Pam exhaled quietly but made no outward show of victory. Karoline's attorney leaned over. We're clear. But Whitaker added one final note. This court, however, remains concerned about the tone and approach taken by Ms. Leavitt during her testimony. Decorum must be maintained by all participants in judicial proceedings. Before anyone else could speak, Pam rose. Your Honor, with respect, those concerns were addressed and dismissed under the federal stay. They cannot factor into any conclusion or public statement. Whitaker's gaze hardened for a brief moment, but he did not dispute her. This hearing is concluded, he said finally. The gavel struck. The sound echoed, but this time, it did not belong to the judge alone. As the courtroom emptied, Pam gathered her notes silently. Karoline turned to her. Is that really the end? Pam shook her head slightly. It's the end of his part. Ours continues. Karoline nodded. She understood. Across the city, in the administrative wing of the Fourth Circuit Court of Appeals, the judicial complaint Pam had filed days earlier had already advanced. Though sealed from public view, insiders knew the review was underway. By the following week, the results were clear, but only to those who needed to know. Judge Whitaker submitted his notice of early retirement. No press conference, no official statement, only a brief memo, effective immediately. I will conclude my tenure on the bench. I remain proud of my years of service. The Fourth Circuit never released the full findings. They didn't need to. But the message was unmistakable. Pam and Karoline agreed to issue no public comment, no interviews, no victory lap. The press filled the gap. Leavitt cleared. Bondi's legal strategy forces judicial review. No evidence of misconduct, a win for legal transparency. In editorial pages and legal blogs, the consensus was clear. They hadn't just won a case. They had demonstrated that the process could still triumph over power. On a quiet afternoon, Pam and Karoline met one last time before returning to their usual work. You handled this with restraint, Pam said. That's rare, and it mattered. Karoline smiled faintly. I had the right counsel. Pam shook her head. You had the right principles. I just made sure the law caught up. They stood, gathering their things. Neither spoke of the judge again. They didn't have to. As the final gavel fell, Karoline Leavitt stood tall, not just because she was cleared, but because she never stood alone. Beside her, Pam Bondi proved that resilience and strategy could outlast even the strongest opposition. What would you have done in their place? Have you ever faced a battle where standing firm made all the difference? Share your story in the comments below. We'd love to hear it. If this journey inspired you, please like, subscribe, and stay with us for more stories where courage and truth lead the way. Thank you for watching.